Have you been sued for a debt by a credit card company or a debt collector? Well, if that's the case, the following information is probably going to be pretty important for you. I'm attorney Shawn Jaffer. I'm a lawsuit defense attorney. We help clients every day that are facing the same issues as you. Now, the reason you're probably watching this video and came on this website is because you probably got served with papers from a debt collection company or a credit card company, and they're probably suing you for a debt. Either that or you got a letter in the mail from several attorneys in the area, some type of advertisement that has told you that a lawsuit is filed against you. So what happens now? Well, the first thing is, in Texas, once you get served by a process server with the lawsuit, which is going to have a summons and is going to have a petition or a complaint attached to it, and probably some other documents, what happens is the clock starts to tick. You have 10 days to file something called an answer with the court. Now, you're thinking, okay, I may not have been served, okay? And if I haven't been served, I can evade the service, and if I don't get served, no lawsuit, right? Nope, not at all. The reality is, what happens is if you evade service, the debt collector or the credit card company is going to go to the judge. They're going to ask the judge for something called a order for alternative service. Now, what that does is it says the judge will listen to the arguments by the credit card or debt collection company, and they'll say something like this: Your Honor, we're trying to serve this debtor at the last known address, and we can't locate them. But, or they're trying to evade service from us. We want you to go ahead and let us nail this lawsuit on their door, or some other method the court approves. The judge almost always grants those requests for alternative service. So what happens is they'll stick a lawsuit on your door, or they'll do something else. And after that, 10 days go by, and if you haven't filed an answer, guess what? They're going to win the case without anything else automatically. They'll get something called a default judgment against you. So you're thinking, yeah, go ahead, take the default judgment. What's the worst that's going to happen? Well, if you get a default judgment against you, a lot of things can happen. The first of those things is if you have a bank account, that bank account can get frozen. The debt collector will send a copy of the judgment, usually over to your bank and savings accounts and wherever else you keep your money. And the next thing you're going to know is you're going to get a letter in the mail, or you're going to get a notification on your banking app. It's going to say, hey, your account has been frozen. And once that happens, there's not a whole lot you can do to unfreeze that account. And if that happens, you can't pay your rent, your mortgage, car payments. You can't get money you can't buy food, groceries, anything else. Everything is, your bank account, your assets are frozen at that point. That's one of the worst things that can happen, and it happens a lot. It happens every day to a lot of clients that contact me. Now, another thing that can happen is that it can show up on your credit report for many years, and it can destroy your credit rating and your history if it shows up under the public records section on your credit reports. Another thing that can happen is that they can send you something called post-judgment discovery. Now, post-judgment discovery is documentation that they can send you over, which consists of things like a request for admissions, which you have to admit or deny questions they ask you under oath. They may send you a request for production of documents, asking you to produce, bank statements for the last year or two. They may ask you to produce your financial records, documents, employment information, where you work, where you bank, your tax returns for 3 to 5 years. Anything related to your assets, anything related to your finances, anything related to your employment, and whatever else that they need to collect the money from you. They can ask you those questions, and it's sent through, so it's a legal process. Now, if that doesn't work, they can also send you something called a request for a deposition, which means that you have to appear in front of the attorney for the debt collector or credit card company, and they'll ask you questions while you're under oath. Now you're thinking, well, what if I just don't comply to any of their discovery requests? What if I just don't do anything at all? What's the worst that's going to happen? What are they going to do about it? Well, this is what happens. They'll go back to the judge, and they'll say, Your Honor, we served the discovery request, the deposition request, whatever, on the defendant, and the defendant has failed to, produce those documents, appear for a deposition, answer our questions, we want you to compel them to do that. The judge will issue an order compelling you to produce those documents or answer those questions or appear for the deposition. And if you fail to appear after that order, they'll go back, the attorneys for the creditor will go back to the judge and say, Judge, they violated the order, they didn't appear, they didn't give us the documents that was requested. We want you to issue an order for contempt. Once that happens, you can be found in contempt of court, and that could result in you going to jail. That's a really likely outcome, as one of the remedies a judge can enforce against you is putting you in jail for failing to comply to the judge's order. Now, all those are horrible outcomes. The best thing to do here is to get ahead of this. Now, the way to get ahead of this is if you've been served, you have 10 days. Make sure you contact an attorney like myself, or contact my office about, retaining us to fight the lawsuit for you. So what we can do is, the first thing we had to do is we've had to look at the lawsuit and respond to it by filing a proper answer. Now, you have to answer the lawsuit correctly, because if you answer admitting things to it, then there's not going to be a case, and there's nothing we can resolve or settle with the opposing side for you. Now, an attorney that practices in this area would know what to look for in a lawsuit. So there's several things that we look at when we defend our clients. The first thing I look at is, was the lawsuit filed within the time period that's required under the law for them to sue you? That's called a statute of limitations affirmative defense. In Texas, they have a number of years to sue you on the debt, and if they don't sue you within that time period, we can raise the affirmative defense of statute of limitations and have the lawsuit thrown out because they waited too long to sue you. Another thing we can look at is, are they suing you for the correct amount? Are they adding attorney's fees? Are they adding collection costs and charges? Are they adding court costs to the debt? And are any of those things that they're adding allowed under the original agreement between you and the credit card company? Now, that original agreement is called a card membership agreement, and that card membership agreement will detail the remedies, things that they're allowed to come after you for in the event of a breach or a default on that contract. Now, sometimes what they'll do is they'll ask you to pay attorney's fees, costs, and collection charges, whatever, and those things may not be included in the original contract. If that happens, then we sue them with a counterclaim, or we bring in a completely new lawsuit altogether in federal court against them for a violation of the Fair Debt Collection Practices Act. That's a federal law that protects you from debt collectors and anyone from debt collectors that are trying to collect a debt in a way that they're not allowed to. Now, collecting attorney's fees or collection charges, interest, and things like that are not actually allowed under the original contract is a violation of the Fair Debt Collection Practices Act, or the FDCPA. Another thing that we will look at is, if they sued you, were they even allowed to sue you to begin with? Now, a lot of these credit card agreements have something called an arbitration clause, a binding arbitration clause. That means either party, you or them, can raise the arbitration clause and have the lawsuit thrown out. Or it may just say that you can't sue them and they can't sue you. So if they initiate a lawsuit while there's a binding arbitration clause, we would just invoke the arbitration clause and try to have the lawsuit thrown out by the court. And in some cases it works. In some cases the judge doesn't really allow it. But it's a defense, and we could try to raise it. And we have been successful at times doing that, many times at doing that. It just depends on the wording of the original contract. Now, if you have any other questions about debt collection lawsuits, please feel free to contact my office. The number is on our website at Jaffer, Jaffer.law, Law.